company C, and when a tender is floated, the bid is by an SPV, which is hundreds of cases like that. They are all really not in every case, because the lordship must have play in the joints, flexibility in the joints to decide. Well, the judges ultimately decide by a feel of the case. According to me, feel of the case is the most important. Their lordship then goes into details. Now, the feel of the case requires justice to be done. The lordship is told strictly there is no doctrine, or the doctrine is so circumscribed that you will not go beyond D. Justice negotiated and performed by D, or rather by C. Is D. And under no circumstances shall there be any liability, any suability, any malicious involvement of C. That will be an important exculpatory circumstance, even there is not binding on a lordship. It will be an important clue to the intention of parties. It's the intention of parties the lordship is searching for. That intention may come from a letter. What is referred to as uncertainty is also going to play in the joints.
Suppose the conduct of the parties are such, and yet they have a letter written by the principal A, that we are nothing to do with this contract. But then they have conducted themselves in a manner which would suggest that they have actively participated.
Exactly.
Then that letter, would that be a defense?
No, that's the point I'm making. It is all in the common hotspot of your lordships gleaning the intention. To do justice has to be seen, not the formality. And your lordships should not, according to me, worry or be anxious about the fact that your lordships can never in any principle anticipate all the myriad cases or situations. Within the existing 16 principles, or any more principle your lordship may add, how is it possible that somebody will get injustice because your lordship has ample principles here?
There is some problems.
Yeah, arbitration.
Because you are wanting an interpretation which is justice-oriented interpretation. Because this is not in the realm of public law. My fundamental problem with this is not in the realm of public law. This is purely a private remedy, purely and absolutely private remedy. Looked at in that context, Section 6 has to be interpreted. Section 7 has to be interpreted. It means an agreement between the parties, coupled with the subsequent sections very specifically saying that there must be a written agreement. Agreement between signatories. So the contract, the requirement of the statute in arbitration law as against what we have in a civil court, where there is a remedy available to anybody, publicly provided, or compare with 226 or 32. These are public remedies as against a private remedy. So when we talk about a private remedy, it must be strictly an agreement between the parties. And to say an agreement between parties can be parties, open-ended parties. And the court will from time to time, case to case, will decide on the facts of a case, who will be the parties, who will not be the parties, depending upon public requirement and justice between the parties on a larger perspective will create a lot of problems. Because number one, every stage of Section 11, you are expecting the court to do an inquiry whether justice requires a party to be brought in or not.
No, let me explain. I'm grateful.
Only consideration so far as contracts are concerned are if it is hit by public policy. Yes, of course, courts can intervene.
So I'm very grateful for the query. Let me just expand on this. This helps me to clarify. Number one, I am not at all saying that your lordship will or will not apply group doctrine on the basis of justice. Please take that as given. I'll put it, lordship will note it down in my submission. That's not at all. And that would be too wide, too open-ended, and it would be actually causative of injustice. What am I saying? I'm saying 2 or 3 basic points. One, 7, for example, Your Lordship mentioned, which is dealt with in my later section E. There are 7 along with 3 or 4 other sections, which I've cited in my section E, are actually indicative of expansion beyond parties in the traditional sense. Not indicative of limitation, but of expansion. In the old pre-96 era, Your Lordship would have more easily looked at only signatories or bilateral, trilateral contracting signing parties. Take, for example, I'm giving a much larger answer, I'm just reacting to the 7 Your Lordship mentioned. Take, for example, B and C of 7. The idea, in fact, is to expand it immeasurably, which could never be thought of by a 1940 Act practitioner. Non-signing parties, non-parties to a contract, who are evidencing a relationship to be bound by an exchange of documents or an exchange of pleadings. I'm doing a running paraphrase.
Right.
Now,
But the problem is that 7.4b and 7.4c, actually 7.4a, 7.4b and 7.4c
yes,
are all indicative of the fact that though the arbitration clause may not be in the parent contract, so to speak, it yet has to emerge from a course of written dealings between the parties. Right? Therefore, in a document signed by the parties, an exchange of letters, an exchange of statements of claim and defense. So all of them, A, B, and C, are instances of a written
parties.
Now what we are trying to explore is whether the extension of the arbitration agreement can take place by a conduct of a party in, say, supporting the contract or implementing a contract, a parent in relation to a subsidiary, so on and so forth. That can we really contemplate when two things. 727 737 arbitration agreement shall be in writing. Therefore, if you impose this now if you interpose this in 7.1, it means arbitration agreement means a written agreement by the party all or certain disputes which have arisen or which may arise between them. Now, between them means whom? The parties to them means the parties to the agreement. Now, parties to what? Parties to the written agreement. I mean, if you take a literal construction of this, therefore, them would mean the parties to the agreement. Which agreement? The written agreement. It can be expanded to include, say, a statement of claim and defense. But then again, it's parties to the agreement.
So, really, who are parties? Who are parties? Who are parties is one of the core questions. Give me two minutes.
And though none of the judgments has considered it, you may also consider it from another point of view of Section 91 of the Evidence Act.
Yes.
See, because once you have a written contract, then any oral evidence to establish the terms of the contract or adding to the terms of the contract is inadmissible under our law. 91 and 91 is underway.
Correct. Well, first of all, let me take it. Interpretation.
You're right about, on the first part, you need not really elaborate the desirability, the fact that Foro has been in the field for 10 years. That absolutely, as a matter of commercial wisdom.
Yes.
As a matter of fact, otherwise what will happen according to you is that you will set up only a shell company and the person behind the shell company will go scot-free. We see all that point. That's all the. But then we now have to find some textual grounding.
That's the point.
Just continuing from what Honorable Chief Justice has said, the play that we have from the previous regime, if you compare both the sections, Section 7 and the section under 1940, of course, there is definitely some amount of expansion. So the fluoro control and the subsequent progeny, as you call them, will have to be fitted within Section 7, expanded, and no further.
Of course.
No further, you can't go further. So therefore, to say justice orientation, so therefore we will see case to case and then see.
No.
It's impermissible. 1 minute, let me just complete. And in Section 7, there is a scope. Section 7 talks about 3 stages. Stage number 1, pre-agreement. Second is during the process of agreement. And third is thereafter. In these 3 stages, if something can be considered akin to a party who is a signatory, it provides to that extent it is permissible. The principle of pro low control can be seen. If you see each of these sections,
Yeah, I
it
know.
talks
Yeah.
about
A, C refers to a document. B refers to exchange of letters,
Yes.
etc., etc. C is a clear indication that can be post-contract also, when disputes are
Pleadings, pleadings.
Because when you file a statement of claim and a defense, that is obviously after the dispute has arisen. Therefore, it is post-dispute. So an arbitration agreement can also be implied when it's in writing, arising from the fact that it is asserted by one party and denied by the other in a claim and defense.
Correct.
Which is after disputes have arisen between them. So one thing is very clear, that the arbitration agreement does not always have to be a pre-dispute arbitration agreement. It can be a post-dispute arbitration agreement also.
So let me, I'm grateful.
And also just focus on later on, I mean, I just raised it, just for the, otherwise I forget it myself. Section 91 will really affect us because
Yes, yes.
91 or 92 of the evidence stand.
Therefore, let me.
But Dr. Singh, you have to give us a little bit of a statutory handle to for conceptualize and formulate. Now,
Next.
before
Straight away. Now let's